Hi, my name is Steve, and today we're going to be talking with Jeffrey Keller, a partner at the San Francisco labor and employment law firm Keller Grover, and a veteran whistleblower lawyer. Our goal today is to clarify some of the confusion about what a whistleblower actually is. The term whistleblower has been used a lot lately in the news. Jeff, can you please clarify what a whistleblower really is as it relates to fraud on the government?
Yeah, sure, Steve. Whistleblower is it's a broad term that you've heard a lot in the news. And really what the way people understand it is it's really to describe someone who reports or blows the whistle on, illegal activity. A whistleblower who is reporting fraud on the government are a special kind of whistleblower that our government really tries to encourage and incentivize to come forward and report that fraud. It's one of the main law enforcement methods that they have to stop and prevent fraud from going on. And so really these whistleblower laws are kind of broken down, or they're broken down into really three different programs. The main program that most of us hear about, or you've seen the news with these big judgments against some of the pharmaceutical companies, is really the False Claims Act. And the other newer program that came out in 2010 is called the Dodd-Frank Wall Street Reform and Consumer Protection Act. And really that law is designed to protect against, companies that are not disclosing material false statements or disclosing false statements and misleading the general investing public and the regulators that regulate public companies. And really the third program is a whistleblower program that was set up by the IRS to really go after people who are cheating on taxes. Really it's for tax evasion in that's greater than $2 million. And so really when you have whistleblowers, whether it's under the False Claims Act for government fraud or the Dodd-Frank for public companies not disclosing material information or issuing false earnings reports, or the IRS whistleblower program, really these laws are all designed to incentivize whistleblowers to come forward, report the fraud or bad conduct that they have. And more importantly, these laws are designed to protect these whistleblowers when they come forward. And so the laws really are designed to prevent retaliation. If there is retaliation, it really does penalize the company who do retaliate based on a whistleblower reporting fraud or tax evasion, or a public company not reporting, true earnings or failing to report, material information. So really these new programs, the False Claims Act has been around for a really long time, from the Lincoln era, and it's been very effective in law enforcement at finding fraud and ferreting it out. And then with all the public fraud that went on with over the last couple years, and with Dodd-Frank, is really a piggyback onto what's been effective with the False Claims Act, is really to stop fraud with public companies and the reporting requirements.
Gotcha. Well, to follow up on that, Jeff, so what are the main types of fraud against the government?
Well, our federal government is the largest purchaser of goods and services in the country. And to a lesser extent, state governments also are very large purchasers. The state of California, is a very large purchaser. So when you look at how our government spends their money, it's not hard to figure out where fraud's going to show up. Our biggest, really the main bucket that you see out there is really healthcare fraud, and that really deals with Medicare fraud, companies defrauding Medicare by providing services that aren't necessary, misbilling for things, charging for things that they don't even do, things called kickbacks where they're paying for patients to come in, which creates these improper conflicts of interest. And under the state side, it's really Medicaid, where the federal government doesn't pay for health care, but the state will kick in either a percentage or cover certain folks that aren't covered by Medicare. And then, of course, our national defense is a huge bucket when it comes to defense contracting, and that can be from purchasing bullets to, paying for military jets, for our space exploration program with NASA. Really anything having to do with the government's, putting satellites in the air for national defense, the national NSA, really anything or anybody who contracts the government that deals with the security of our country national defense will fall into that bucket. And it's a very large bucket. So all these entities that contract that are committing fraud are maybe brought up under False Claims Act. And then there's just generic government contracting, or installing street lamps, at the local level to government programs. For example, government land where they lease, energy rights, oil, gas, to private companies, and the government gets a royalty. If they're falsifying what that royalty is, it could be a False Claims Act case for that. It could be really any government agency, Department of Labor, gives grants to do research on, whether or not there's discrimination is a problem in this country. Anything, the Small Business Administration, where they will give contracts to small businesses or to minority businesses or to veterans. All of those programs have requirements, and if a company or individual falsifies the application to get into those programs to get government money, they may be subject to the False Claims Act. I mean, another entire area is programs where you're required to pay the government. For example, you've got customs duties. If you falsify your custom tariffs, that could be subject to false claims liability. So really, anything you could think of that touches where the government's either paying or collecting money could be the subject of false claim liability. On the Dodd-Frank side, another big bucket is any public company that's issuing earnings reports quarterly, or if there's a material change at the company. They're obligated under various federal laws to report those material changes in their business, or if there's a problem with the earnings. Really, the whole purpose between Dodd-Frank, which piggybacks on the Sarbanes-Oxley laws that were put in after Enron failed, is really designed to make sure that the investing public has full and complete accurate information. And if somebody works at a company and they know that they're not disclosing material information to the public and to the SEC as part of their quarterly reports, that's an entirely new bucket that started really in 2010 with the Great Recession, and it's really designed to keep our public companies and our financial markets honest and transparent. And then the last real big bucket is tax evasion. The IRS has a whistleblower program that if there's tax evasion with taxes and penalties, interest above $2 million, you can report that, and again, there's the opportunity to get a reward. And really what all these programs are really trying to incentivize and protect are people who have information that the federal government, state governments don't have, to get them to come forward, and when they do come forward, have laws to protect them so that they're not retaliated against. So those are really the main buckets. Really, pretty much anything that you could think of that's a public service or a public, you're selling something to the government, from pencils to fighter jets to satellites to pretty much everything that touches our life could be the subject of a whistleblower claim, and where the whistleblower could get a percentage of whatever is recovered on behalf of the government and be protected under the retaliation laws.
You mentioned retaliation, and to me that brings to mind, what are the biggest concerns for the whistleblower? Is retaliation the biggest concern? What else do they worry about?
Well, it's interesting. Whistleblowers are courageous. They're heroes in our book. I mean, these are the folks that are almost genetically engineered to come forward because they see something that's wrong and they can't sit back and not do anything about it. So these folks take on huge responsibilities to report it to their supervisors. Obviously, the company is not going to be happy if you're reporting that they're committing fraud and you're highlighting it. So you see, companies will start, ostracizing that person. They'll take him out of the really nice corner office and put him in the basement and lock him in a closet. They'll demote them. They'll fire them. And so really, most whistleblowers that come to us have already been fired. They've been retaliated against because they tried to do the right thing, and typically doing the right thing is, in their view, is going to their supervisors, to their management, saying, hey, you guys are committing fraud. This is wrong. We shouldn't be doing this. And the company will try to prevent them from voicing that concern any further. They'll cut them off from the information, and they'll fire them. And then they come to us and they find us. And really, under the Dodd-Frank laws, which are very strongly designed to protect whistleblowers, the False Claims Act, again, really strong protections. But the thing about the way the laws work, they're really, really technical. And so one of the things when whistleblowers come to us, really want them to come forward even before they blow the whistle. But the laws are designed, and really if a company retaliates against a whistleblower, and it's protected conduct, and really that protected conduct is really why you need to talk to a whistleblower lawyer before you blow the whistle to make sure that your conduct is protected, is that the protections are, under the False Claims Act, there's double back pay. If you get retaliated against, you're fired, they have to pay twice what your earnings are. They've got to pay the interest that in between the time that you're fired until they were repaid that amount. There's reinstatement if that's something that the whistleblower is interested in doing, to the same seniority that they were when they were fired for engaging, reporting fraud in the protected conduct. And there's there's other compensations, paying for your attorney's fees and stuff like that. So there are really protections, but they're very specific and very technical in nature to make sure that they're protected under the law. So again, if a whistleblower is contemplating disclosing it or reporting it to their supervisors, I really recommend that they do talk to a whistleblower lawyer first before they do that.
Yeah, it's funny, you mentioned that they should talk to a lawyer first before they blow the whistle. So really, what do you see as the first steps that they should take before they do that? Contact the lawyer, and then what?
Like any other employment issue, understanding your rights is probably the most important thing you need to know. What are your rights if you do report what you know? What are your employment rights? What are your protections? And really what we will do when whistleblowers come to us, we really want to disclose to them the rights that they have, the protections, the laws they have for them, and what are the ramifications if they do come forward and report the fraud. And those are the things that you really got to understand, that there's multiple steps here, and it's not just whistleblowers, like I said before, they're sort of programmed to try to do the right thing, and absolutely doing the right thing is what we support our whistleblowers. I mean, they're courageous, they're heroes in my book, and we go to great lengths to try to make their lives easier and help support them through this process. But when you're reporting fraud, you have to decide who you're going to report that fraud to. You can report it to the company internally, or you can report it to one of the federal or state agencies. That's a decision that the whistleblower needs to figure out. You need to figure out whether or not that what you're reporting is actually illegal, what the conduct the company is engaged in, is it illegal? You want to decide whether or not you should report it at all, because if you're reporting something that's not illegal, you may get retaliated against because of that report, because the company is going to say that you're not loyal to the company, and there may not be any protections for you because what they're doing is not illegal. So you want to make sure you understand what they're doing, get the advice of a whistleblower to see whether or not what they're doing is illegal, to decide who to report it to and whether or not to report it. Another thing that most whistleblowers don't fully understand is that a lot of companies require them to sign confidentiality agreements. And those confidentiality agreements talk about what information they can report to who. If a lot of whistleblowers, they want to report it to the media. They want to let the world knows what's going on. The problem is if you do that, you don't have any protections under either the False Claims Act or Dodd-Frank for reporting confidential information that you've signed an agreement not to disclose. You may be subject to lawsuits by the company. You may be subject to having to pay damages, pay their attorney's fees. So you need a lawyer to help you analyze and understand what your confidentiality agreement is, what your rights are under the laws, and whether or not who you can report that information to. So really, our firm, Keller Grover, we take great pride in representing whistleblowers, and our firm is both an employment firm, so we've got employment lawyers who can deal with those employment issues of retaliation and specifically understanding confidentiality agreements and how they affect the employment context. But we also have our firm has been doing fraud cases for 20 some odd years. So when you deal with our firm, you're getting kind of best of both worlds. You get lawyers that can help you on the employment end. You can have lawyers that can help you on developing the fraud aspect of these whistleblower cases, because you have to present this case to the government in a way that the government's going to be interested in bringing it, or we're going to bring the case ourselves and be able to prosecute it and be successful in that. And the one thing I have to say I'm really proud about our firm is that we really go out of our way to not just help our clients legally, but emotionally. It's stressful. Any lawsuit's stressful. But when you're in a whistleblower and you're taking on a company, it's you against them. It's sort of the David versus Goliath. And our firm is really, we spend the time and energy to help our clients emotionally through this. It's a difficult time. I provide my clients with my cell phone number. They can call me day or night. We're there for them, and it's a lot more. Clients tend to be anxious. They're nervous, and having somebody, knowing that there's somebody there to talk to, who's on their side, who believes them and is going to advocate for them, helps with those anxieties. So really, those are the reasons about, the steps that whistleblowers should take. They really need to talk to a whistleblower first before they do anything, to make sure that what they're doing is, one, that the conduct is illegal, two, understand their rights, and make sure they report the fraud to the proper entity, whether it's the company or the proper agency.
You anticipated my last question. I was going to ask you about, with your labor and employment background and the whistleblower background, what made you guys unique to be able to help them, and I think you answered that very well. So I think what I'm going to do is just say, for more information about reporting government fraud or to get help with your whistleblower case, contact Keller Grover Lawyers at reportgovfraudnow.com, or call the whistleblower helpline at 866.486.1537, and that could be done at 24/7. And let me just show one thing here, and there we go. This is how to contact. There we go. Thanks.